Good morning, afternoon, or evening, depending on where you are listening in from. I'm Michelle Bender, legal counsel at Ocean Vision Legal. We're the first law firm worldwide to entirely specialize in marine protection. We solidly stand on two legs. One, enforcing existing legal obligations and holding states accountable through ocean litigation. And second, advancing alternative legal pathways to restore and protect ocean health, including through ocean rights and ecocide law. I created the Ocean Rights Framework in 2017 to address a large gap in the rights in nature movement. Hundreds of laws, judicial decisions, and policies have been passed recognizing the rights of nature, but less than 5% of them are specific to or refer explicitly to the ocean, marine ecosystems, and marine species. Through this work, I have explored to what extent and how this framework can protect the ocean and marine species such as sea turtles, sharks, and whales. And so today, my particular focus with this presentation is the specificity of ocean rights to marine wildlife, and walking through some examples of where we're seeing this in the movement, but also how we can see this looking in the future, because this legal framework is still emerging. And as I noted, there's very little case law or laws in general that are specific to the ocean. To start, I just want to share a general overview of the philosophy and assumptions behind rights of nature. In general, Western legal systems are anthropocentric, meaning they instill a worldview of humans as separate from nature, and nature as a resource and property here for human benefit and utility. On the other hand, rights of nature is the legal recognition of the inherent rights and intrinsic value of nature as a whole or for specific ecosystems or species, as well as the human responsibility to steward nature on behalf of present and future generations of all life on the planet. The philosophical and ethical underpinning is that all beings have rights and intrinsic value merely for existing. It is in this sense that rights are recognized, they're not granted. Law, therefore, aligns under this ethic and respects and protects the complex and diverse relationships between and with humankind and nature by imposing legal duties on all human beings and persons to take measures to ensure that they do not infringe on the rights of nature. Both an assumption and a challenge with this movement is the relationship between rights. Sometimes there can be a perceived competition between human rights and the rights of nature. But I want to highlight that human livelihood and the realization of our rights are dependent upon a healthy environment to support them. We can't have human right to food, for example, without the environment being able to provide that food. And we can't have infinite economic growth on a finite planet. Now, there's no one-size-fits-all approach to this legal movement. But this graph highlights the growth we have seen, at least up through 2021. We've, of course, have had many, landmark decisions and laws passed in 2022 and 2023, but this just demonstrates the growth. And I want to highlight that the legal content, the form of the law, its scope, it very much depends on the goals, the legal system, the political and cultural values that are present. But in general, we do have three pathways that are emerging within rights of nature. One is where nature as a whole is recognized as a subject of rights. And this is what we see in Ecuador in their 2008 constitutional amendment, as well as Panama's National Rights of Nature law that was codified in 2022. We also see ecosystem-specific applications. So rivers, national parks, lakes, and forests are being recognized as legal entities or legal persons subject of rights. And then finally, the focus of today, specific animals or species are also being recognized as having inherent rights and intrinsic value in our legal system. A recent case in Ecuador called the Estrelita case, it really demonstrates how animal rights relates to the rights of nature. This case involved a woolly monkey known as Estrelita that was taken out of the wild. And the Constitutional Court established that the rights of nature constitutional amendment, even though it was broad to nature as a whole, it applies to in this instance because animal rights are a specific dimension of rights of nature. So animal rights constitute this specific dimension with its own particularities. The rights of animals are held by specific members of the animal kingdom, while the rights of nature are more generally applicable to the existence of all natural species, to the maintenance and restoration of ecosystem processes as a whole. And this includes abiotic elements as well, so air, CO2, water. This case, another thing that the judgment did was it introduced what are common rights of wild animals. And so this can really inform its application in the marine space as well. The right to naturally occurring food, health, habitat, free locomotion, and free development of their behaviors. Now, as a subject of rights, then, wild animals are protected in their right to life within two dimensions, both a positive and a negative. The positive being protection of their rights, such as through legislative measures and regulation, and at the same time punishment and remedies for when these rights are violated, which also leads to the prevention of the violation of these rights as well. Now, we've seen time and again that no matter how progressive or strong a law might be, if societal values do not shift to honor and lift up that law, it will be ineffective. It will lack enforcement. Rights structure the form of governments, the content of law, and shape morality. In other words, rights are the fundamental normative rules about what we allow or is allowed of a person or entity recognized as having rights. Therefore, legal rights are based on societal values and able to fundamentally transform law and the effectiveness of law. As noted by the Constitutional Court of Ecuador, the central idea of the rights of nature is that nature has value in itself, and that this should be expressed in the recognition of its own rights. The recognition of and respect for intrinsic value of nature is therefore a critical principle in almost every rights of nature law. Additionally, the notion that nature has worth and is worthy of protection just for being itself, outside human benefit and utility, is an underpinning principle as well, leading to proactive protection. I do want to mention that rights is still a Western construct. So the rights of nature, animal rights, they're not fully a divergence from our Western legal system, but somewhat of a meaning with it because of this use of rights as a Western construct. Many indigenous and coastal communities, they don't need rights to recognize and respect nature because this is inherent in the worldview and customary practices. So I do want to acknowledge that in some instances, some communities, there could be tension between wanting to use this framework as a way to respect our interconnected relationship with the natural world. There are many ways in which legal subjects can be classified. They can be classified according to whether they are individual subjects, such as humans, or collective subjects, such as communities of indigenous peoples. What you will see in this movement is different language, and I want to highlight some of the considerations here because we'll see subject of rights, legal entity, legal persons used quite synonymously, but they're not always. And the reason for that is when we're saying animal rights, such as cetaceans, we're not saying that that cetacean is a person. A legal person is not a human being, but rather an entity to which the law grants specific rights. The rights and responsibilities of a legal person, therefore, vary according to the nature of the entity. For example, corporations and human beings have different sets of legal rights and duties. For example, corporations may assert freedom of expression, but are not protected by the right to life. In other words, humans have human rights, rivers have river rights, and fish have fish rights. From a practical perspective, when a living being or entity is recognized as having rights, it means that others have a corresponding responsibility to uphold and respect those rights. So human beings, we have responsibilities and duties to nature, but not necessarily vice versa. The language use really came to a forefront in the case in India involving the Ganga and Yamuna rivers, where the High Court ruled that the rivers were legal persons with all the corresponding rights, duties, and liabilities of a living person. Now, the court really blurred this important distinction between legal rights and human rights by conflating the legal person with the living person. And it's important, for the success and effectiveness of this movement going forward, that we do not conflate this difference, and that, if we're using animal rights, they can be designated as legal persons, but it's important not to say or to have language or provisions in that law that correspond their rights and duties and liabilities to a living person. Enforcement mechanisms to ensure these rights can be upheld is a vital component of robust rights of nature laws. Rights recognition is just the first step, and these laws are unlikely to have any direct impact unless they are given legal effect. Therefore, ensuring legal effect through the establishment of ecological standards or criteria, as well as principles, is a main focus of our work at Ocean Vision Legal. Creating structures for nature's interests and intrinsic values to be represented in decision-making is manifesting itself as a primary pathway to ensure implementation and enforcement. And there are two main mechanisms that I'll highlight today: standing and guardianship. Standing is seen as a challenge, especially in the United States, to sue on behalf of the environment. Standing is the legal right to bring a suit, and it involves meeting certain criteria, such as demonstrating injury or harm to the plaintiff, as well as the court's potential remedy to redress that injury. On the other hand, rights in nature opens a door for those who may speak and act on nature's behalf, and therefore better challenge decisions that may harm the environment. Many rights of nature laws, such as the Constitutional Amendment of Ecuador, provide specific citizen suit provisions, allowing all citizens and entities the right to enforce and defend nature's rights. On the other hand, guardianship is also emerging. And for the most part, this mechanism is in instances where specific ecosystems or species are recognized as having rights, such as the Wanganui River or Te Awa Tapua in New Zealand. A main difference between guardianship and standing is the positive dimension of rights, the proactive implementation versus judicial enforcement through legislative measures that respect and ensure those rights are upheld. So in the instance of Te Awa Tapua, they created a management board comprised of these guardians from both the local Maori iwi communities as well as the Crown government. And within this act, they have an explicit legal responsibility to represent the river's interests and intrinsic value in decisions and disputes affecting its health. So we could see how guardianship might lead to a balance of interest in decision-making, proactive, and instill a partnership ethic where we recognize and respect the fact that humanity is just one part of the natural ecosystem, and that we need to respect all ecosystem linkages. It's a way of considering populations and ecosystems to have a seat at the table rather than just be on it. Now, I want to just do a comparison with two main species protection laws in the United States, so we can see some more of the tangible differences provided by rights of nature, and also how rights of nature might help address the gaps that exist within existing environmental law. So the Endangered Species Act. This is a law that once a species is seen as threatened or endangered, they can get listed. And then that listing status confers protection. Particularly, there are quote unquote take prohibitions for listed species. So it makes it illegal to harm, kill, or harass a listed species. It also prevents agency actions that are likely to jeopardize that species' continued existence. Unfortunately, this law only kicks in once a species is on its way out. So once it's already threatened or endangered, rather than aiming to keep those populations healthy in the first place. Additionally, there's no right to life for these listed species. And as a result, no positive dimension to protect that right to life. And this is really important because having this lack of a dimension allows for exemptions to come through, and it allows for human interest to outweigh conservation interests. And we can see this through the quote unquote God Squad provision that actually allows agency actions to jeopardize the existence of species if they see or think that the costs of conservation outweigh the benefits of just letting the species go extinct and letting us use the environment however we want to. Additionally, the Marine Mammal Protection Act is perhaps one of the United States' strongest protection laws for marine mammals, and actually has served as an international example for other countries to follow because of the zero mortality goal and a strict prohibition on any harm to marine mammals. But with this one, just as with the Endangered Species Act, there are exceptions. And those exceptions can come into play with permits that can be authorized to take species if they are for specific purposes, such as scientific research, captive display of cetaceans, for example. And this permitting question with captive display animals under the MMPA was actually discussed in the case of Citizens to End Animal Suffering and Exploitation versus New England Aquarium, which actually demonstrated the difference between rights of nature and specifically the representation of marine mammals' interests and the MMPA, which does not allow citizen suits. So at issue in this case was whether the transfer, purchase, or sale of an already captive dolphin, constitutes a taking, which would require a permit. The court found that the MMPA does not authorize suits brought by animals, only brought by persons. And if Congress had intended for this law to allow representation of marine mammals, it would have explicitly said so. This is not surprising though. Asserting that human or that animals' needs and desires must be given serious consideration is quite progressive from a global perspective. This language is really rare in the United States legal system, even though it's starting to emerge internationally. Now, I want to highlight a few examples of where rights of nature is occurring specific to animals. This year in Panama, sea turtles were recognized as a subject of rights. And in the Loyalty Islands of the French territory of New Caledonia, sharks and sea turtles were recognized as natural entities. Additionally, in India's high courts, there have been rulings recognizing all animals, including avian and aquatic species, as legal entities and allowing guardianship by all citizens to represent and enable them to act for non-human animals. Now, I do want to highlight that with all three of these laws, actually, we don't have much for how implementation or enforcement has looked like. And that's a big gap in the movement. And that's, why Ocean Vision Legal exists, why we're here to address that gap, is to really make sure that these laws are implemented and enforced. So with some of the examples going forward, even if these cases aren't specific to marine ecosystems, I will show how we can have them apply. Particularly, a lot of the case law is emerging in Latin America and in Ecuador. Over 60 cases have been adjudicated in the name of rights of nature in Ecuador, including 3 involving illegal shark fishing in the Galapagos Marine Reserve. In 2017, a Chinese vessel was found with over 6,000 dead sharks. In Ecuador's constitution, not only is nature recognized as having a right to maintenance and the regeneration of its cycles, structures, functions, and evolutionary processes, but nature is recognized as the right to be restored, and that this restoration shall be apart from the compensation to people. So in its judgment, the Ecuadorian Supreme Court ruled that not only the captain and crew that were responsible for this act were to receive prison sentences, they were also fined approximately $6 million US, noting that nature, as a subject of rights, is entitled to complete reparation from the crime, and that the amount necessary as compensation depends on both material and immaterial damage caused. This is such an exciting decision, not just for rights of nature, but the environmental movement generally, because not only did the court recognize that Ecuador has a duty to protect the rights of nature, but you could see that we're starting to head in this direction of collectively realizing that we are interconnected with nature. And there gets to a point where we value a living shark, a living, thriving population of apex predators who are vital to ecosystem functioning. That value is worth more alive than dead. Now I have 2 more slides to walk through that I want to demonstrate how rights of animals and marine wildlife may positively impact marine conservation, including through fishery management. Maximum sustainable yield is a long-standing global policy tool to determine the maximum harvest of a population that is sustainable in the long term. And I want to draw attention to that strive for quote unquote maximum, because that focus of what is the maximum we can take out of the system without preventing collapse is part of the paradigm that needs to change. Maximum sustainable yield, it largely lacks the ability to consider ecological and environmental conditions, changing conditions like climate change, the needs of the system as a whole, as well as cumulative impacts. This focus on maximizing the long-term exploitation of a system has proven counterintuitive. Exploitation often relies on government subsidies, which without the cost of fishing, particularly in the high seas, would exceed revenue. And unfortunately, the use of scientific data for the determination of what is optimum and what that fish catch should be is not always binding. In fact, a recent survey showed that the use of scientific data is binding in only 26% of countries and economies, and that it will be ignored for higher fish catches. As a result, some recent studies show that approximately 34% of all fish stocks are overfished within the high seas. In fishery management decisions, scientific advice is to help facilitate the adoption of the precautionary approach, not the opposite way around. It's also supposed to help us restore and maintain these populations so they live on in perpetuity. Traditional cost-benefit analysis and environmental impacts assessments, we largely see conservation as inefficient. when looking at the cost or loss of profit from reducing fish effort, rather than efficient when looking at the long-term profit that will occur from keeping a population healthy. As a result, we tend to allow those harmful fishing techniques, such as bottom trawling or pursing fish nets, because they give us a higher yield. So they give us more yield for the effort we're having, so we make more profit, but we're also causing a lot more impact to the environment, such as through bycatch. On the other hand, a rights-based approach would determine fish catches based on what allows the entire ecosystem, which includes humans, to meet their basic needs. A view of sustainability from the ecosystem's point of view, or what we call ecological sustainability. So instead of aiming for the most we can take out of the system without collapse, we aim for maintaining thriving and healthy populations in the first place. And to do this requires strict adherence to the best available science, as well as recognizing different ways of knowing, including indigenous and traditional knowledge. Traditional knowledge has proven vital to understanding and sustaining the interconnected relationship with the ocean. For example, that knowledge is fundamental to understanding the connectivity of marine species and processes between areas beyond national jurisdiction and coastal waters. Altogether, a rights-based approach may lead to more precaution in decision-making, a systems approach that takes into account cumulative impact. In our cost-benefit analyses, we would look at the short-term monetary gains or losses, but also take into account the intrinsic values of a living and thriving ecosystem, as well as other neglected values such as cultural values. This helps us really start to see that measures such as marine protected areas and no-take zones are actually efficient in the long term. And then therefore, this would lead to positive regulations such as the prohibition of destructive techniques that can lead to the permanent alteration of habitats or lead to the extinction of species such as bottom trawling. Now, two more lines of thought that emerged for me while I was going through the Estrelita case in Ecuador is one, the balancing of interests, and then new criteria for how we can apply this to wild marine animals. So we know that while humanity's needs may never generally be weighted less heavily than nature's because human bias is inevitable, what this case demonstrated was that human rights do not trump nature's rights automatically or in all circumstances. When we are looking at the balancing of interests, there needs to be a proportionality test between human rights and the rights of nature. This case introduced the ecological interpretation principle as a principle that guarantees the protection of animal rights. For example, they used the human right to food, particularly when balancing those rights in fishing decisions, stating that the right to food the human right to food must be ecologically interpreted or consider and respect the biological interactions that exist between species and between populations and individuals of each species. So we're not saying no fishing altogether, but that there needs to be a balance of these interests and that the human right to food has to look at, well, what allows the ecosystem to stay healthy at the same time. The case also established, as I noted, some rights for wild animals, and one of these rights was the right to free locomotion. So through a discussion here, the court established criteria for the adoption of measures by authorities that would lead to the limitation of this right to free locomotion. They noted that any decision that could lead to a limitation of this right of wild animals should be sufficiently justified. Therefore, it needs to have a legitimate purpose that is suitable or appropriate, necessary, and proportional. So we can imagine this these standards coming into play when we're thinking about migratory species, for example. I'll focus on the necessity standard. Necessity is satisfied if the methods, actions, and tools employed are the least harmful and cause the minimum possible environmental impact. That, to me, light bulbs go off. Let's look at the protection of whales and increased shipping collisions. Is it of necessity to be having as many boats as we have at the speeds we have them in our coastal waters and in the high seas? Some would argue no, including myself. This is largely, the faster speeds. That's a convenience, not a necessity. So if we had the recognition of rights of nature, rights for whales in place, one such regulation that would be a direct obligation to enforce and respect those rights could be shipping reductions or shipping speed reductions in their migratory corridors. So rights of nature, as I noted, is relatively new and the understanding is constantly developing. But as you can see, it's one tool that can really help us move towards a future where we respect non-human species and we recognize our interconnectedness with them. It could also help really solidify these principles of protection and prevention while moving us away from the purely anthropocentric approach to cost-benefit analysis and environmental impact assessments. If you have any questions, whether it's ocean rights in our campaigns or ocean litigation related, please feel free to reach out, get in touch with any questions you have. And we look forward to working on this and gaining international recognition of the ocean rights together.